Hello, everybody, and thank you for joining us today for this virtual spotlight session on protecting privacy and ensuring data flows, a practical view. My name is Aaron Cooper. I am Vice President for Global Policy at BSA, the Software Alliance. BSA represents the enterprise software industry. We operate in more than 30 countries around the world and represent some of the world's most innovative software companies. Today's Spotlight session is hosted by BSA, and I'd like to thank Forum Europe for their support in organizing the event. I miss being in Brussels in person for these events for a number of reasons, not the least of which it is a much more civilized time right now in Brussels than it is in the US. For those of you who are just joining us, a couple of housekeeping notes before we get started. This session is on the record, and a video recording will be available after the event. I'd like to encourage everybody to make use of the chat function to send questions to our panelists, which we will try our best to answer over the next 45 minutes. So data and digital technologies, like software, are increasingly at the core of how governments and companies and even educators across sectors use to operate on a daily basis. In Europe, almost 80% of large companies and 35% of small and medium-sized enterprises use information sharing tech software, for example. The way that we are able to participate today and improve on video conferencing services is all about using data to learn and understand and improve all of our lives. Through the COVID pandemic, the reliance on digital technologies and software, particularly across borders, has only increased, and the importance of cloud technologies and the visibility of that importance has increased as well. Companies in Europe and around the world are therefore relying more than ever before on the ability to access data, sometimes including personal data, across international borders. Another reality, as we just heard from the previous panel, is that standard contractual clauses are the main transfer mechanism used by 90% of companies that transfer data internationally from the EU to virtually every country in the world, 180 countries, including Australia, Singapore, Brazil, India, Mexico, and now the United States as well. This just reinforces the importance of having strong privacy protections for personal data when moving across jurisdiction. From a BSA perspective, we want to emphasize that there should be no trade-off between the need to transfer data and the need to protect the privacy of that data. Both are essential. Personal data should only be transferred or used in any way with real and effective privacy protections. The CJEU's ruling in Schrems 2 was a major milestone in guiding the collective reflection on what types of data protection is necessary in order to transfer data. And we've seen action not just by the CJEU, but also the Commission and the EDPB to try to develop solutions to square the circle about the interests of needing to transfer data and the need to make sure that that data is kept private. The issue is getting a lot of discussion, not just in the US-EU context, but also around the world, and trying to figure out how to make sure we have a harmonized system. But we have two great panelists with me today. Both represent member companies of BSA. We first introduced Cornelia Cutterer, who is Senior Director for Rule of Law and Responsible Technology at Microsoft Europe. Her group focuses on the impact of new technologies and regulatory frameworks that meet the expectations of society. She began her career in the European Parliament as an advisor to an MEP. I'm very excited to have Cornelia here today. Jason Albert is Managing Director of Public Policy for Workday, where he leads the company's worldwide government affairs engagement on tech policy issues. Before joining Workday in 2016, Jason was at Microsoft, and he's been lead privacy counsel at several other major companies, and began his career at Covington and Burling, where I had the pleasure of following in his footsteps. We're really excited to have both of you here today. Let me kick off by asking both of you a question. Maybe Cornelia, if it's okay, I'll ask if you could answer first. One of the things that the Court of Justice stressed was the importance of considering transfers that rely on standard contractual clauses on a case-by-case basis, taking in all the circumstances of that transfer. I think there are a lot of technical discussions about what that might mean, but maybe you could give us a sense of when Microsoft is dealing with its enterprise customers, what are the kinds of questions, the kinds of concerns that your customers have? I noticed in your bio, one of the things that it talks about is new technologies and regulatory frameworks that meet the expectation of society, and I think that frames this really well. That seems like the cornerstone of what Microsoft, Workday, other responsible enterprise software companies care about in dealing with their customers. I'm curious, what kinds of questions do you get from your customers about what you do to protect data?
Yeah, thanks, Aaron, and thanks to you and BSA for inviting me here as a member to your great organization. This is, of course, a broad question. Let me start with marketing saying of Microsoft. Microsoft runs on trust. There's likely nothing more important today where technology overall is very comprehensive and invasive, that people and customers and organizations, when they digitally transform, they need to trust the companies that provide the technologies on this journey. So that's sort of the first important part. Now, going to the specifics of the Schrems case, and of course, this discussion really didn't start with the court case rendered in July, but rather this has been a very long and over almost like 10 years or so now, discussions in how to enhance personal data protection and privacy. So with the court case, the first thing that Microsoft did is, of course, moving all our contractual relations to standard contractual clauses, in particular those that were based on the Privacy Shield that was invalidated with the court decision that you referred to. Of course, the European Data Protection Board has immediately put out, and thankfully so, some first frequently asked question, which gave some guidance in which way this is going. But we see, of course, also a lot of questions coming from our customers, and really not only related to our obligations as a processor and their obligations to do certain safeguards and put safeguards in place, but also to any other international data transfer that they might have. I just recently spoke with a bank in a given country that was quite worried about all their initiations that they had put in place now to digitally transform themselves. And as you said, Aaron, of course, in the context of COVID, this speed of digital transformation was a necessity for all European companies. So understanding exactly how they can put safeguards in place is, I think, the most important question that we need to answer today. The European Data Protection Board guidance or recommendations, I shall say, I think there's a slight difference here, are of utmost importance to provide some clarity. And I'm pretty sure that we're going to speak a little bit more in detail about the recommendations that have been published in the draft. Microsoft has also always had additional protections for our customers, in particular commercial customers, public sector customers, that go beyond simple compliance with GDPR. And we have doubled down just now on those with our Defending Your Data principles that we have published mid-November to specify in more detail how we are about to defend our customers' data and that of their users. And we can, I'll go into more detail eventually later. I want to give the opportunity also for Jason to say a couple of words.
Thank you, Cornelia. I have several follow-ups to that, and look forward to discussing it in a minute. Jason, can you talk a little bit about what data flows. What do data transfers mean to your customers, and why in the real world they're important to businesses in Europe?
Absolutely, Aaron. And again, thanks to you and thanks to Forum Europe for this opportunity to talk about this issue. Workday, for those who may not know us, we're not perhaps quite as well known as Microsoft, is a company that provides human capital management services and financial planning and analytics. So think of us as providing back office services related to human resources management, general ledger, financial planning, analytics, and things like that. And so when you think about personal data, you really think about it in the HR context. And if you're a company that needs to process transactions, you need to transfer an employee from one location to another, you need to process an expense report, you need to do performance management across your organization, you need to know how many employees you have at the start or end of a given day. That requires bringing all of the data together to be able to process those transactions, right? You can't sort of keep it segregated, by office or by country or by region. And so, the services that we offer, we give each customer a tenant that has their data in it, and data transfers are very important, both to be able to bring all that data together in a single data center region to enable the processing of those transactions, and also because our customers tend to be multinational, whether they're large enterprises, whether they're medium-sized enterprises, and they have employees, in multiple countries, if not all over the globe, and again, need to be able to have a view into that data and to be able to manage their employee populations, to be able to process transactions, to be able to, offer training and learning through learning programs and things like that. So for us and for our customers, data flows are very important because of the fact that commerce and companies, cross borders in the modern world.
Thank you. Yeah, I've often, when we're discussing data flows, particularly in the U.S., which doesn't have restrictions on the way data can be transferred, and we talk about why it's important both for companies on both sides of the Atlantic with policymakers, particularly on Capitol Hill. One of the questions that we get is, one is why is it so important? And then two is there's all this discussion of it, but we don't see disruption. And I think a large part of that is because of the work that Jason, you and Cornelia and others do to try to figure out how do we make sure that we're complying with the court's decision and the recommendations from data protection authorities, from the commission in the form of revised standard contractual clauses. And it's a lot of effort that goes into making sure that data can continue to move seamlessly so we don't see it. It's the kind of thing that when it's happening right, our services work and our packages are delivered on time, and we can have a conversation like this with, in various locations. When it doesn't work, people really notice. Cornelia, you started talking about some of the specific extra measures that Microsoft has been putting in place after the Schrems decision. And could you talk a little bit more about what that entails and what it means to try to come up with additional safeguards that will protect data coming out of Europe, whether it's going to the US or going to one of the 180 other countries around the world?
Sure, Aaron, and it's very kind that you think I'm doing all of this. Of course, as many of you know, we have our Chief Privacy Officer, Julie Brill, who leads an organization that then coordinates with all our engineering groups across all our services what type of organizational, legal, and technical measures need to put in place. And with a company as big as Microsoft, of course, this is a large undertaking. It's also not, as I mentioned before, not necessarily a new one. And so we could also rely on some of the safeguards that we have provided to our customers at their will, unrelated to the Schrems decision. But of course, in the context of that decision, we have gone back and looked at making those technical, legal, and organizational safeguards even more effective. So one safeguard, for example, that we have already demonstrated, that we provide strong protections for our customer data, our transparency practices, and our efforts to also legally defend our customer data is, I think, on record. So in the latter case, we are committing that we will challenge every government request for public sector or enterprise customer data from any government where there is a lawful basis for doing so. That's a strong commitment, and we do believe it goes actually beyond the proposed recommendations of the European Data Protection Board. Second, and then we'll provide monetary compensation to these customer users if we could disclose their data in response to a government request in violation of GDPR. Again, here we do believe that this goes beyond the draft recommendations. It also shows that we have some confidence that we will protect we are confident that we will protect our public sector and enterprise data and not expose it to inappropriate disclosure. We've called these protections defending your data, and have started also to add them into our contracts with public sector and enterprise customers. It makes really substantial additions to our foundational privacy promises and the protections that we already offer to customers. There is, of course, a focus on technical measures that we use. We use strong encryption and provide that with a high standard, both when it is in transit and at rest. Encryption is obviously critical in the draft European Data Protection Board recommendations. But we also need to recognize that the court itself has not specifically favored legal, organizational, or technical measures. So we'll probably have a discussion around that. Interestingly, is of course how we protect our customers' data in other ways. Transparency, I mentioned already. We've made for many years already information available about government demands for customer data, and have also here fought to be able to disclose more than originally was possible. So again, here, I think our commitment to transparency has proven valid in terms of our ability to with legal success, increase the ability to demonstrate and to be transparent about practices.
Thank you. Thinking about additional safeguards, in October, BSA had put out principles for additional safeguards to help provide companies, particularly those that were transferring enterprise type data, the types of additional safeguards that might be helpful in meeting the Court of Justice's standard. But one of the things that we had discussed internally was whether to suggest individual clauses and provide examples of how this might play out. And I think one of the conclusions we all reached was because the court indicated that we need to take into account all the considerations of the transfer, it's really not possible to without using a million pieces of paper demonstrate all the different permutations, all the different variations on additional safeguards that would be appropriate depending on the nature of the transaction, the organizational protections that companies already have in place, the likelihood that the government is going to access the data on transfer and things like that. And so we went with a much shorter one-page set of principles because they need to be adapted. And that seems like one of the difficulties that you see the EDPB struggling with legitimately is the difficulty of trying to put out solid guidance in a situation where the types of data and the types of company transferring that data is so different. Jason, would you like to talk a little bit more about additional safeguards and what that means from a Workday perspective? Otherwise, I have a second question that I want to follow up with you on.
Well, I'll talk, but I'll keep it brief so that you can get to the second question. I think when we think about additional safeguards, I think it's always important to go back to the Schrems 2 decision, right? And the court there, I think, took a very principled but yet also pragmatic approach. It said, look, you have to look at the law of the third country and whether there could be potential government access to data. But at the same point, when you evaluate any particular transfer, you have to look at it on a case-by-case basis. You have to look at the data that are being transferred. You have to look at the applicable law. You have to look at the additional safeguards. And as you point out, there's a range of things, right? Many types of data are very uninteresting to governments, right? They tend to focus a lot, for better or worse, on communications, because those are things that can be used to plan terrorist attacks and the like. There's a lot of data being transferred, whether it's HR data or whether it's sales data, that just are never accessed, aren't interesting. And then, there's a range of measures. Cornelia talked about encryption at rest and in transit, both of which are very important, both of which we do as well as part of our overall comprehensive privacy program. Having a strong foundation of privacy compliance and organization to look at where data is traveling, be understanding how it's mapped, how it's being used, I think is important. And then there's a series of additional contractual measures and commitments, like contesting any access request if one were ever to receive one, that are valuable. And none of those, I think, is more important than the other. You have to look at the combination in light of the particular individual transfer.
So that is a very complicated analysis that companies have to do, and it brings me to the other question I was going to ask. Cornelia talked about how addressing these issues is not just something that she does, but there's a whole, but there are many people within Microsoft that think about these issues and try to make sure that data can be transferred safely and securely. And the same thing I know is true at Workday. There are a lot of small and medium-sized businesses that need to transfer data as well, and your companies do that on their behalf sometimes, and sometimes companies have other alternatives. When you talk to your customers, particularly small and medium-sized companies that use your services, how complicated is this for them to have to navigate? When we talk back in the U.S. about what the Privacy Shield being invalidated means for both for our companies and the companies that they serve, one of the things that we talk about is it is a problem for BSA and for BSA members not to have the Privacy Shield, because I think that was a very effective transfer mechanism with a lot of privacy protections built in, and annual reviews and things that are really good for ensuring privacy. But 70% of the companies that were certified to the Privacy Shield are small and medium-sized businesses, and they can't be dedicating the same amount of resources that the companies whose main function centers around the ability to process data for their customers. How do you both see the impact on small and medium-sized businesses?
Well, I'd step back for a moment and I'd say, Aaron, I think there's both the ways that we can make it easier for them, and then, the ultimate role that policymakers can play. So, one of the things we do at Workday is that, we have a transfer impact assessment, around our services that we can provide to help them evaluate, how we protect data that's transferred, the protections we offer, the mechanisms we use, how that complies with the court's decision. And I know BSA, for example, put out even a model transfer impact assessment template for companies and others to use. And that's great, but again, that probably only helps the businesses to the extent that they're using our services or any other company that does a TIA. I think you're hitting on a point that in the long run, we do need a successor framework to Privacy Shield, right? Standard contractual clauses can be used. They can be used with these supplemental measures. The court expressly held that they could continue to be used, and we're, all doing the work that you described to, have them in place and to put in place the additional measures to comply with the Schrems 2 decision. But in the long run, a set of protections that go across the industry, that go, across, whatever companies an enterprise or transfer is dealing with, is important to provide both a level of consistency, and also because we know that those protections, particularly in the intergovernmental space, are going to serve as an important backstop and background for how transfers even under SECs are looked at. So even for companies that never would certify to a successor framework, although I hope many would, that framework will still inform how their transfers occur under contract. So even though we continue to enable data transfers, we believe that it's possible to do so consistent with the court decision, and that we do it. And I know Cornelia and her colleagues at Microsoft do it. We shouldn't mistake that for saying that we don't need to move swiftly and purposefully towards getting a new framework in place between the EU and the US.
Thank you, Cornelia. What are your views?
Yeah, I think Jason put it really rightly, and there's not much to add. Maybe just in other words, the burden, I think, on small and medium-sized enterprise that might not necessarily just do business in Europe, but they might actually be in international companies. The size is not necessarily the defining way of whether they are global as a company or local. So I think, yes, it puts more burden on them. They will not have the same resources to invest in doing assessments of each country before they transfer data. It's really highly complex to assess a country's adequacy. I think that's a proof point of how complicated it is, even for the Commission, who is trained in doing so. That's the one thing. The other thing is, of course, that we can indeed, as Jason said, we can provide the assurances. We invest a lot of resources, not only in the personal data protection, but also in the security of our services. We have trust centers that make available all the certifications that we provide for the divorce services, and provide all the clarity. We have the contractual ability to also provide legal backstops and legal assurances in this context. But as I said at the beginning, we also hear, of course, this is not only a matter of the contracts our customers have with us, but they have other initiatives that where they are worried about. And to a certain extent, it is an interesting consequence of the decision that we will now reward more to adequacy decisions. I think it has, as a political consequence, at the first stance, it is for the European Commission to really invest a lot of resources, not only in renewing an improved privacy shield with the United States, but also with many other countries, as they have been doing over the last couple of years, and really speed that process up, because it seems that is the only way where international data transfers can function without overburdening, in particular, small and medium-sized enterprises. So in this vein, I'd say we are actually quite enthused and optimistic that the European Commission and the US administrations are looking intensively in how to advance or start the negotiations in that matter.
Thank you. The discussion of adequacy determinations, like the Privacy Shield, and trying to recreate that, and also other places around the world, brings me to another question. We talked at the outset about how 90% of companies that are transferring data from the EU are using standard contractual clauses, because almost every country does not. There are very few countries that have adequacy determinations with the European Union, so SECs are the principal transfer mechanism. We do see countries that look to the GDPR as a model for their privacy law. I mean, the Commission's objective in getting the GDPR to be a model in a lot of places has been very successful. In some places like Japan, for instance, there's compatibility and now an adequacy determination with the EU and a system, privacy system that is not identical to the GDPR, but as the Commission determined, does provide an adequate level of protection. So it's sort of based on the norms of that country, and going back to Cornelia, your part of your job description of meeting the expectations, the privacy expectations of whoever's data it is. In other places, take India as an example, there's also been an effort at passing a privacy law is intended to be based on the GDPR in order to achieve an adequacy determination, but that is quite different in some respects than the GDPR, and the Commission has even weighed in to say that data localization provisions, for instance, go too far in the Indian's draft privacy proposal. I'm curious whether you see the move towards trying to get adequacy in different places around the world, whether that has led on a good trajectory or in some places a more problematic trajectory in other countries that are looking to try to create a similar privacy system.
Go ahead, Cornelia.
Okay, thank you, Jason. So first thing is GDPR was talked about as a golden standard, and of course we have seen over the last couple of years around the globe privacy regulations being adopted. So this is, I think, generally a positive development that we have also expanded the GDPR protections not only to citizens of the European Union, but more broadly, so that others can also benefit from data subject rights. This said, the adequacy decisions are actually a process that take a couple of years, so we'll also need something in between. So the standard contractual clauses, in particular, those that the Commission is now going to publish, remain absolutely important. So while this is as I mentioned, it's a positive effect that we will hopefully have more global standards to easily transfer data around the globe, at least amongst those countries that can adhere to the essential equivalence standard. The standard contractual clauses will remain important, and of course the ones that we have now seen in a draft and that are also
Did we lose Cornelia? Oh, there she is.
Oh. Can you still hear me?
Yeah. Yes.
Good.
Jason, any views on it?
So what I'd say, Aaron, is we always have to step back and recognize that privacy is a fundamental right. And like any right, it's important that it be protected. So the move to adopt privacy laws around the world is a heartening one, because the more that are adopted, the more people will have this fundamental right protected. And it's equally important that privacy laws be interoperable with GDPR for a couple of reasons. The first is obviously the need to ensure cross-border data flows in an increasingly integrated economy. But the more basic one is that GDPR and the Data Protection Directive before it is based on the OECD privacy principles, and those provide a very solid framework for how you protect privacy rights to ensure that people have adequate protections, they have notice about how their data is being used, that they have the right to correct it, that there are obligations on downstream recipients. And so I think it's entirely possible to create a strong, effective privacy regime that reflects a particular country's legal structure, right? In the U.S., we have a very different legal culture and legal background than most of Europe. But at the same time, is interoperable, consistent, and offers the same protections. That's why we at Workday have called for comprehensive federal privacy legislation in the U.S., based on the OECD principles. And so, I agree with Cornelia. Adequacy decisions will take time, but on the other hand, by having increased privacy laws, interoperable with GDPR, and adequacy decisions eventually coming, that will set up a framework in the long run that will be very successful. And then in the short and medium term, we continue to have the standard contractual clauses. And one thing I'd say about the Commission's new clauses that Cornelia referenced is that their approach, particularly on evaluating third countries' laws in the case-by-case approach, is a really solid one, where they take account of organizational measures, they take account of technical measures, they take account of of additional contractual commitments, the nature of the data access. They look at the law of the third country, not in terms of just what's on the books, but how it's applied and the likelihood of access, all of which really reflects the court's guidance in the Schrems II decision.
Do you think that the type of convergence that we're starting to see on the commercial privacy side, the move towards a federal privacy law in the United States, in different places around the world, using the OECD principles as the baseline for creating privacy protection, do you think that we can see a similar convergence and interoperability on the government access side, where governments that are like-minded in needing to have some intelligence, law enforcement access gathering, but also respect the fundamental rights of their citizens, can get together around a set of principles. I know there's some work at the OECD on this and in other places to try to get to a consensus on what that should look like with like-minded democracies. Cornelia, any thoughts on that?
Yeah, thanks, Aaron. I like that question. It's interesting, and it's also promising that compared to 5 years ago, I think more or less 5 years ago, when we were sort of after the Schrems I decision, starting to have a conversation. I might be wrong, but the numbers, so don't pay attention to that. After Schrems I, when the European Commission had to renegotiate the Safe Harbor Agreement, what became the Privacy Shield, it's interesting that many of the issues that were touched upon in the Schrems II decision have been on the table for negotiations. Some of which didn't make its final round into the Privacy Shield agreement. However, I think there has never been such a hyper focus on, is there a possibility to start a discussion around national security in this context and amongst democratic countries. So that is now a little bit changed. I think this is a long-term conversation. It's certainly not an easy conversation, and I cannot even say where this is landing, but that the OECD has taken this up in at least starting to formulate principles around it, I think is a very promising first step. And it's also a really necessary step. I'd say, of course, in the context of Schrems, we're really talking about national security and proportionality about measures in this context. Let's not forget that at the same time, we're also looking at the EU-US law enforcement agreement that hopefully can now advance. We have just this week heard about the development in the context of the e-evidence proposal, which sort of was the missing part in really having the European Commission being able to negotiate. So all of these steps we're seeing, they were all not easy to. There's a lot of questions around this, but yes, I think there is eventually for the first time a real possibility to actually advance this conversation.
All right, so Jason, Cornelia just laid out an optimistic viewpoint on the future, which I love. Jason, when you think about the next several years and what data protection and data transfers are going to look like, do you have an optimistic viewpoint you can share with us as we get close to wrapping up today?
I do have an optimistic viewpoint. All right, I think that the convergence that we talked about is going to continue to occur. I think we're going to see in the next couple of years, comprehensive federal privacy legislation in the U.S. We see countries, that have privacy laws updating them. We see other countries adopting them. I think, it's important, and Cornelia talked a little bit about this at the outset, that we have to create a culture and environment of trust. Right, data powers so much of the modern economy. Everything, artificial intelligence and machine learning, as well as the services that we all know and love. But fundamentally, people won't let their data be used if they don't trust that it'll be protected. And I think that need for trust and that environment for trust is ultimately what's going to drive increased adoption of privacy laws, increased convergence around this set of principles. And I think as we see that, that will, of its own accord, help address some of these data flow issues we've been talking about here today.
Thank you. Cornelia, can I ask for final remarks from you? Do you share the optimism about how companies will interact with their customers to instill trust, and that will be one of the driving factors?
Absolutely. And I think what a very important point, which is not only related to data protection, but it is also related to data protection, is artificial intelligence, of course. And in this context, I think the implementation and operation of ethical principles that most companies have put forward now that align very well with those of the OECD, with those of the high-level group on AI of the European Commission. These will allow us to even improve, I think, a holistic approach to build technologies that are really human-centric. And it almost goes beyond what GDPR has promised us. So I'm super excited about the ability that we have when we are now applying standards in the context of responsible AI that really will help us. And there is a lot of work, and this is eventually my last point on this, in the context of artificial intelligence, in research and really making privacy, in building technologies that are privacy friendly around machine learning. There's so much research going on and so much promising initiatives that I'm actually very confident that those will help provide the confidentiality requirements that people rightly so request in the context of those data flows.
Excellent. Well, thank you very much. I want to thank Jason and Cornelia for joining, and Forum Europe for helping us host. Really appreciate everybody being here. And thank you. Have a good day.
Thank you, Aaron. Bye-bye.
Thank you.
Thank you.